The court is yet to receive the law court file, thus a ruling cannot be issued instantaneously. The Learned Honorable Magistrate having ordered that the applicant be detained for 3 days from 1st of July 2026. This court directs that at the close of business today, and for avoidance of doubt, at 5 p.m., the applicant should be released from police custody. Then number 3, ruling on Monday, 6th of July 2026, and the DR is directed to avail the law court file by noon today.
Would wish to point out that the matter being investigated upon before the law court is a cognizable offence.
But under investigation
by dint of section 29A of the CPC, a warrant is not required.
as by dint of section
29A, my lord.
section
A warrant is not required.
29 cap or small?
Small.
Small.
A, yes, a warrant is not required.
CPC warrant.
Which would therefore state that the arrest was lawful, which was done on the 30th of June this year. And the applicant was presented before a court of law on the 1st of July, within the 24-hour threshold allowed by law pursuant to Article 49 of the Constitution. So there was no violation.
Presented to court being 24 hours.
There was no violation of her rights. And in saying so, my lord, I would rely on the case of Casina versus the AG.
Casina.
Yes, versus the AG. It's a 2024 KLR, where the court stated that it is not every arrest that would amount to violation of fundamental rights and freedoms. My lord, upon arrest of the applicant, as correctly stated by my colleague who appears for the applicant, items were recovered,
Upon arrest,
which were duly captured in an inventory that has been annexed as annexure number 1.
and an inventory. Prepared. See,
And my lord, section 25 of the CPC provides that upon arrest and without a warrant, items recovered from a suspect can be seized. Which again would demonstrate that the recovery was lawful and within the threshold of the law.
Mr. Mogere,
Yes, my lord.
you mentioned a cognizable offense, and
Yes.
you did not go further to say what offense it is,
Sorry, my lord.
so that when I retire to do a ruling,
Yes, my lord.
I need to know whether indeed what you're saying is a cognizable or non-cognizable.
Sorry, it is a cybercrime offense,
The offense
contrary to section 27 of the Computer
And,
Misuse.
investigation is a cybercrime offense
Under section 27, my lord.
under section
Of the 27, 1A,
1A
of the Computer Misuse and
of the
Cybercrime Act,
computer.
which is a fact that was also...
Just a minute,
Sorry.
computer misuse and cyber Act. Is it affected by the decision by my sister yesterday, Judge Nyaunde?
My
You
lord,
know what decision she delivered in that section?
I am not privy to it.
Okay.
But I will acquaint myself. Basically.
Yes.
Father, my Lord, it is not true that the accused person did not understand why she was being arrested. And the IU is also on standby virtually.
Applicant did not understand
It was explained to her.
why she was being arrested.
And Father, she was presented in court on the 1st of July. Whereupon she was represented ably so by counsels.
She presented court by counsel. Did the court comply with Article 49 in explaining to her why she was under arrest?
My Lord, it was explained by the IU under oath.
No. When you appear in court under Article 49,
Yes, my Lord.
isn't it a requirement that the court, you are either charged or it is explained to you? Did the court explain to her?
That
To your recollection? Or you are not the prosecutor in the court?
I wasn't, my Lord. So I'm not privy to that.
But you say the IO explained.
Yes, there is a demonstration of an application that has been annexed to the application that shows why indeed she was being presented before court in compliance with the provisions of Article 49, that within 24 hours to be presented and to be explained to why it should be kept. And my Lord, as I stand before you,
Yes.
I have not had my colleague challenge the custodial orders that were issued, whether they were improper, whether the law was not considered, but rather there have been averments as to the search, arrest, and the non-reporting or booking of the applicant from Mombasa to Nairobi, which in itself, my Lord, does not invalidate the custodial orders. So basically, my Lord, they're basing their arguments on procedural issues.
Is there any reason why she was not presented in Mombasa, in the Mombasa courts?
My Lord, the reason as to why she was presented in Nairobi is to expedite the investigations, because the unit within which she was arrested by is based in Nairobi. And the resources required to analyze the gadgets that were recovered are based in Nairobi.
Because the unit...
So this, my Lord, was to expedite the investigations and to make a decision on whether to charge or not to charge the applicant.
You are saying the equipment needed to investigate?
Yes, based in Nairobi, my Lord. And my Lord, this is a matter of public interest because the items being investigated upon refer to a public figure who is a symbol of national unity.
You are not ready to say who that is. This is a matter of public interest for it concerns.
My Lord, that is subject to investigation, so I don't have much
A
information.
public figure. I'll just put that.
Yes. So we believe, my Lord, that the trial court indeed exercised jurisdiction and applied the law correctly in giving the said 3 days and not 7 days as prayed for.